Hello, everybody. Welcome back to Wednesday Night Live from Courtroom Confidential, the fastest growing true crime news channel on YouTube. Don't believe me? Go ahead and fact check me. I invite you to. Thank you, everybody, for being here on a Wednesday. Again, spending some time with us. It's good to see all of the familiar faces and some new names in the chat. Hello to Barbara. Hello to Alicia Kay. Hello to Pammy. And Jill and April. Thank you guys so much. I always want to make sure I shout out as many names as I possibly can because you know what? You're taking time out of your busy days to spend a little bit of time with us while we chat about what's going on in true crime news. Lots of fun stuff to get today. You will notice we're a little bit earlier than we usually are. And there's a very small baseball game. Jay, what's happening? How you doing, my friend? Good to see you. It's live now. Isn't it like lunchtime there? Yeah, practically. By the time I usually eat, if I eat at all, this is usually when it is. But there's a small baseball game or a series of baseball games that have been going on. And one of those is taking place this evening. And so we wanted to accommodate you folks so that you could make sure to still watch the game. And by folks, I'm saying one person in particular was very concerned that they would be able to watch the game. The Dodgers are up 3-1 on the Yankees. Let's go Dodgers. No offense to all my Yankees fans in the chat, but let's go Dodgers. I hope we bring this one home. I was having a conversation with my friends about do we want to win tonight or do we want to bring it home to LA to win? And I nearly slapped all of them saying, don't you tempt the gods. Get the win when you can get the win. We'll celebrate however we need to celebrate. But again, all respect to my Yankees fans in the chat and who are watching, but I really hope the Dodgers bring it home. Anyhow, of the things that we plan on discussing this evening, one, Sarah Boone, there was a verdict. I know you all know about that, but there were also press conferences done by her attorney, Owens, that I wanted to play for you folks because I thought they were very interesting because keeping it in that sports theme, he did a press conference with Court TV directly after the verdict, which was amazing to me because it reminded me of those post-game interviews that they do with the manager of the losing team that's just so brutal for them that they have to sit through it, but they have these media obligations. So you get this person who nearly wants to pull their hair out, has probably just got done having an awful conversation with their team in the locker room, and now they got to go out and answer a bunch of questions by reporters asking them, why did they all make all these mistakes? And Owens had to do basically the same thing for Court TV. And he did a little interview with Ashley Banfield from News Nation that was especially harsh. So I wanted to play that for you guys as well and just chat a little bit about it, what's going through his head, and what are these questions that he's giving. And I mean, what are these answers that he's giving and how much of that can actually be believed? Pardon me, Jay, you're fantastic. Thank you for gifting the membership. Speaking of gifts, last week we had a couple of gifts from Laura Waldy and Robin McBroom, who gifted memberships as well. So I wanted to make sure to thank you guys if I missed you last week. Also, Lori Vallow, Doomsday Mom, Lori Vallow, now says she wants to represent herself in her trial in Arizona for another murder and an attempt murder. Holy smokes. So we'll chat a little bit about that and what that means. But first, we did a first in our series of interviews that we plan on doing on this channel, what we are calling Courtroom Confidential Conversation Series, where we want to interview creators and contributors to the true crime space, talk about where they came from, what they're doing, how they got to where they're at. It wasn't, we wanted to focus more on them and less on, let's talk about a bunch of cases. And we kicked that off on this Monday. If you missed it, please check it out. But it was with Gisela of Grizzly True Crime, and it was fantastic. So because of that, our channel got a huge bump in subscribers. So hello to all the new subscribers. I hope there's some of you in the chat. She has a tremendous, wonderful community that she has built that call themselves Grizzlies. They're all fantastic, supportive, positive people. A lot of wonderful feedback on that. And if you haven't seen this, the video already, please check it out. It is the #1 viewed video on our channel right now. So if we were at all curious as to what would be the response from all of you folks about starting this brand new series of interviews, we got our answer right away. So we're very excited about that. Hello to all the new Grizzlies in the house. And stay on this stream to the end, because I have an announcement about our next interview. And I think you guys will enjoy that and be excited about that one as well. We've really outdone ourselves, and I hope we can keep the pace up of the interviews that we've set up, that we hope to give you guys a behind the scenes glimpse of some of the people that you're already fans of. So I know this is a long intro and I try to keep them brief, but a lot of people I want to thank, and some of that is our new members. So here's some of the people that joined up since last week. I'm not going to get into all of the names, but I'll try to cover them throughout the evening. But we had Aspiring Court Reporter, The Boss Lady, Cooler by the Lake, Kickboxing Mom, Aunt Nancy, Madeline Bullet, Lolly77, Samantha Valentine with no E, Squinting Cat, Forrest Nelson, and Christina. Thank you guys all so much for joining up in our membership program. If you have more questions about membership, for some reason, the battle between YouTube and Apple products, or maybe it's all cell phones, makes it incredibly difficult to sign up. And I get questions all the time. How do I become a member? How do I sign up? You actually have to open up a computer and go to your laptop and click on the join button, or we will try to make it easy and put a link in the description of this video to make it easier for you guys. But let's jump into what we were planning to jump into, which is the interview of Attorney Owens, who got stopped by the court TV reporters right as he's leaving the courtroom. And I'm going to play it for you guys. Maybe I'll stop it if we find something especially interesting. But it was just remarkable to me, because we live in a day and age where you see this kind of stuff, where it wasn't this way years ago, right? It used to be just, oops, sorry, I messed something up there. Let me try this again. It used to be that, attorneys kind of did their work in the dark. Whoever was in the courtroom got to see the triumph or the embarrassment of them losing, and maybe a couple of news reporters or something. I had one experience when I was a prosecutor of doing a trial. There, that's better. Of doing a trial in front of TV cameras. And it was just added another level of absolute stress and exhaustion to the whole thing. It was completely surreal. So I empathize with what Owens was going through during this. It was completely surreal to be doing your work in court, putting on your case, and then on my commute home from work, I was living in a place where I would commute by train during that time. I would be sitting on the train on my phone, looking at the news coverage, analyzing what happened in court that day and how I did. And it was absolutely surreal. And then since that time, that was many, many moons ago, but since that time, court TV has had its rebirth, and it's even more involved now, to the point that these attorneys get outside of the courtroom and they're even stopped to give an interview. So let's jump into this interview with hold on. Why am I messing this all up? Let's jump into this interview with him, and there we go. Take a listen to see what he has to say.
We, the jury, find the defendant guilty of murder in the second degree as charged in the information. Sylvania, dated in Orlando, Orange County, Florida, on the 25th day of October 2024. The form has been signed by the full person.
Madam Clerk, please poll the jury.
Jury seat number 1, is this your true and correct verdict?
Yes, it is.
Jury seat number 2, is this your true and correct verdict? Yes, it is. Jury seat number 3, is this your true?
Yes, it is.
Jury seat number 4, is this your true and correct verdict?
Yes.
Jury seat number 5, is this your true and correct verdict? Yes. Jury seat number 6, is this your true and correct verdict?
Yes, ma'am.
Sarah Boone found guilty.
All right, there was the announcement of the verdict. I wanted to show that to you guys if you hadn't already seen it. The polling of the jury thing is especially anguishing when you're an attorney on the losing side, to have to hear all those people say that they agree with the verdict while they stare you down and your client down. If you're on the winning side, it's fantastic, and it's like, you know, getting to take a victory lap every single time it happens. Sheila points out juror number 3 is everyone's kind of spirit animal in this whole thing, where he didn't even wait for the question to finish before he shouted out, yes, he agrees. So we certainly know how he felt. All right, let's skip ahead, though, to this interview
With Sarah Boone's attorney, Kelly.
Hey there, Vinny. Yeah, it didn't take very long for the jurors to return a verdict in this case. Sarah Boone guilty of second-degree murder. We are joined now by her defense counsel, who advocated for her vehemently throughout this trial. This is James Owens. James, what's your reaction to the verdict?
Just disappointed. Sarah's devastated. She's disappointed. We felt like we had a good defense with the facts that we had. Obviously, we had some hurdles to overcome for the state's evidence, and for whatever reason, the jury didn't see it our way. We respect the jury's decision. I'm sure that Sarah Boone is going to want to appeal. I believe that she does have potentially 2 or 3 good appellate issues. So the next thing in store is, I think we've got sentencing set for, I believe, Monday, December the 2nd at 1:30. And we intend to call Dr. Harper as a witness to speak about her other mental health issues that she struggles with, and hopefully the court will consider that.
Mr. Owens, Sarah.
Okay, first of all, do you see what I'm saying? I mean, you could replace him with a very sweaty, basketball player at the end of a game, and it's the same type of thing. We gave it our all. We tried our best. You know, it was all about execution. As far as criticizing what this man is saying at this point, what else is he gonna say, right? We tried, we expected something different. I mean, he's not going to stand there and say, we saw this coming. Well, then what are you doing the trial for? We're disappointed. She's shocked. Of course, you're going to hear all of these things. My point isn't so much to ridicule him as much as it's to say, how else, what are we going to expect? A truly honest answer out of him, or an answer that's kind of giving a little bit of coverage like this? The one thing that was interesting is he talked about how he wants to call the expert to testify about at her sentencing, which is allowed. They're allowed to present further evidence at sentencing, and that evidence can extend beyond what was even allowed at trial. So it can be, even the things that maybe the judge kept out of the trial, as far as experts testifying to certain things about her mental health. That is all something that the court should consider and take into consideration. Remember, the judge has some discretion here because the basement is 22 and a half years, but he has discretion from there to life as far as sentencing her. So he's, he's going to want to hear everything, and she's entitled to have that heard. So that's why he's saying that they're going to go ahead and get into the expert's opinion that as far as the why am I blanking on this? The battered spouse evidence.
Was offered a plea deal in this case, manslaughter. She did not take it. What do you think now, having the verdict?
Well, ultimately, that's their decision. They've got a couple of fundamental decisions. One is whether to plead guilty to anything, and the other is whether to go to trial, and the other is, whether to testify, and then the other is whether to appeal. And so Sarah Boone maintained that she wanted a trial the entire time, and we did discuss, there were plea negotiations, and there were offers on the table for the lesser charge of manslaughter, but Sarah ultimately rejected those offers and wanted her day in court.
She felt it seemed throughout this entire trial, she seemed to be very upbeat. It seemed, though, I was getting the sense she really felt she hadn't done anything criminally wrong.
Well, I think, I believe she's a better spouse, and I believe she believes she's a better spouse. Once she learned, and we gave her a bunch of material about the subject, once she learned, what she had gone through with George Torres, I think she believed she was a better spouse. So we believed in that scenario that she was justified in defending herself. And so she felt good because she had a defense and she had lawyers. Initially she was going to represent herself, and then she did that for a while. And I think she appreciated the fact that we came in, myself, Tony Henderson, and Kevin Beck, and then our team. We had 5 or 6 people working on the case for the last 45 days trying to get ready for trial. And I think she appreciated our efforts. She knew we were working hard. I've been here in Orlando for 3 weeks, and then the rest of the team's been here for 2 weeks. So we've been doing everything we could do to represent her to the best of our ability, and that's what we did with the time that we had.
You really put up.
I do appreciate the spin he's putting on this as far as giving himself a little bit of an out. He's basically telling him, I did the best with what I had here, folks. No smoke thrown his direction, by the way. Good for him for I think everybody understands the position you were in, sir. But one thing that I thought was interesting in that answer is, at least the impression that I got was this idea of battered spouse and her understanding of it. He seemed to say came after their discussions with her, but also after her decision to go to trial. In other words, she was hell-bent on going to trial from day one, it sounds like. And it sounds like part of the reason, and again, we're probably never going to really know, but part of the reason she burned through those previous 8 attorneys was based on her decisions to go to trial, and was based on the idea that she had this offer on the table. I think that offer of involuntary manslaughter, by the way, or manslaughter for 15 years or whatever it was and change, I don't think that was an 11th hour offer. I think that was probably something that had been floated around for a while, and they may have been going back and forth on that. And I think that she was just dead set on going to trial from the very beginning, and had just burned through attorneys partially because of that, partially because of probably her insistence of having the trial handled a certain way. I mean, he's correct in saying that's her decision to go to trial. That's her decision to turn down a plea. Nobody can force that upon you. That's her decision to go ahead and testify. This played out, what we're hearing here is this played out exactly as she wanted. She got all that she asked for. Okay. But the interesting part about that is, to me, she was heading to trial even without battered spouse, even without self-defense. She would have headed to trial representing herself and just put on an argument. And they presented her with this battered spouse idea and this self-defense idea that, criticize it all as much as you may, but it sounds like that was not the deciding factor, whether or not battered spouse was on the table. And then she decided, oh, I have a defense here. Maybe we do go to trial. I think it was, we're going to trial, Mr. Owens. How would you like to defend this? And they came up with battered spouse, which, by the way, wasn't laughable. Well, maybe, but not laughable to the extent that they couldn't stand up with a straight face and make that argument.
A good fight. Were you surprised that the jurors came back as quickly as they did?
I was. I think that, the rebuttal evidence where they played a bunch of videotapes of off Sarah's phone, where there were some interactions with Sarah and George, I think that affected the jury.
What do you think? Another big.
That's an interesting way of putting it. Interactions, by the way. You're talking about the flat out abuse of this person, of this man, caught on video. Carry on.
Was for you.
Well, of course, the suitcase video is difficult to deal with. And then, her interrogation, the 2-hour interrogation at the sheriff's department. So, I mean, we had evidence. That's probably the best evidence in a case is the videotape oftentimes is the best evidence. And, we had some big hurdles to overcome. And obviously the jury, and I respect the jury's decision, saw it a different way than we presented.
During your closing arguments, one of the things that you talked about was we're in 2024 and the perception that the state may be trying to give that she in a way deserved this, that she was the aggressor. You talked about how men are taught not to put a hand on a woman. I thought that was pretty powerful. I thought that was going to resonate a little bit more with the jury.
Yeah, I think that, it was a long trial and the testimony came out, the state got in a bunch of evidence about, like I said, the video interactions between George and Sarah. And some of that, it seemed like Sarah was berating him a little bit and talking down to him a little bit. And, the state had argued that this was a mutual abusive situation, that Sarah verbally, emotionally maybe abused him. So I think there was some of that going on. In the relationship. It was a dysfunctional, toxic relationship. Obviously, those two didn't need to be together, but they, for whatever reason, they could not stay away from each other. And even when she had been battered multiple times by him over time, for whatever reason, they couldn't break up. And it just, I think everybody around, law enforcement, the neighbors, family, all knew how bad the situation was, but for whatever reason, they were drawn to each other and couldn't let go.
The judge made it clear before the verdict was read.
I mean, the other thing to keep in mind here is she's still got appeals out there. He can't really share his thoughts on her during this because he doesn't want to mess up her appeal. So he's doing a bit of a tap dance here. Quite frankly, it's a little bit shocking he even did the interview, but he does this and another one.
He did not want any outbursts in the courtroom. We had one earlier from George Torres's family. No real reaction from Sarah Boone. I just saw her talking with you, but obviously, as you were mentioning, seems to be not very happy, devastated with the verdict.
Yeah, she couldn't believe it. We were optimistic. We were optimistic, and I understand, these things happen, and there's a murder charge. So, somebody died. So it's difficult for a jury sometimes not to come back with something, and they came back with the highest charge. I was hoping maybe for something lesser, but we understand. Sarah's in shock. It happened, and then she was escorted out of the court fairly quickly, so we really didn't get a chance to talk that much. She said she would call me tomorrow. I'm going to be driving back home, and we'll talk. I'll be on the road for 6 hours, so we'll talk for however long. But I explained to her she had a right to an appeal, and she had 2 or 3 good appellate issues. So I told her to keep her head up.
Mr. Owens, you were not her first attorney. She went through several attorneys. How was she to work with?
She was fine. I think once she realized, it wasn't just me, and I spent a lot of time down here with her. And then once she realized Tony Henderson really helped me out a lot with Sarah Boone. And, I've represented some difficult clients. I've been doing it quite a while. But Sarah, was, of course, she didn't want to give up the power because she'd had the case for 4.5 years. She had so many different lawyers. So, but I think once she started to trust us and realized that we really cared about her, we really believed in her, and we wanted to do everything we could to fight for her, I think she finally, it didn't take too long for her to develop a sense that we were really genuinely trying to help her. And I think once she saw how hard we were working and everything we were trying to do to help her, we didn't have a problem.
And you got involved with this case because you saw that she had taken out an ad.
Yeah, as you know, the court had ruled that she forfeited her right to a lawyer, a public lawyer. And so she was going to have to represent herself. And I think she went to a couple of hearings and realized that that's a lot harder than it looks. And that's when she had reached out for somebody in the private bar to take the case. And I came down and visited with her, and I agreed to do it. So we were in it to win it. We tried everything we could do to present the case in a fashion that the jury would consider her side.
I think one of the biggest moments was when you got the experts of the states to talk about the fact that she did believe that Sarah Boone suffered from battered spouse syndrome. I thought that was going to be a big game changer for you.
Well, it was, I've got some disagreements about how that was all handled because she came out with an opinion that she had never expressed before.
And then you had to conduct a deposition right there in court.
Yeah, I've never had to do that. That was a first, but it was a unique situation. Of course, the judge had set a date certain about trying the case. So I had the case for about 45 days, but we tried to schedule Dr. Warner's deposition. I believe we took it on October the 4th. And then later on, she came up with another opinion that I wasn't aware of until in the courtroom. And so the judge...
Just want to pause it for a second. First of all, to say hello to Gisela and Grizzly True Crime. Thank you so much for joining us in the chat. You're absolutely right. If you think she was shocked by the verdict, wait to see the shock she's going to get by the actual sentence on this thing, because I do not think she's going to get the low end of the 22 years. We'll get into that a little bit more later, but sneak preview, torturing someone to death is probably not something that a judge is going to view with all that much leniency. But Gisela, thank you so much. I told everybody what a wonderful interview we had and that they should all check it out, and that your community of people, you guys run deep. The Grizzly crew runs deep, and they're all fantastic, wonderful people. So hello to you, and hello to your whole Grizzly crew. But again, I'm seeing people in the chat point out how Owens went after the family when they were emotional in court, and how he had these arguments that were hard to swallow and everything else. And I agree. I mean, of course I agree. Of course I agree that this guy, did a lot of stuff that made you kind of pinch your nose. I guess what I'm saying, though, is that here he is, just on the heels of a very, very public defeat, and still has to get the courage up to give one of these, like I said, post-game interviews. Is just got to be brutal for him. And he's doing this tap dance. We tried our best. They just didn't see it the way we saw it. I mean, just substitute everything for what he's saying about, they've got a great team over there, and they've got a lot of talent. We just put this together about as well as we could. It's just one of those interviews. But I think he is at least shedding a little bit of light on her personality. I mean, one thing he said was, once she trusted us and realized that it was something along the lines of she was going to have to give up some power. So that is what it was. This was a client that wanted to steer the ship. This was a client that did not have much faith in her attorneys and wanted to control things. And perhaps this gentleman either said, lady, you're in charge, just tell us what to do, or she finally trusted someone. But it's amazing that he got through this whole thing. I thought he was going to get booted off the case by her mid trial, but now he successfully got through it, and his reward is this interview.
Allowed me to take a deposition. Never heard that before. First time it ever happened, but it did. And we did the best that we could to counter that, and then to cross-examine her. But yeah, I think initially she had said she hadn't made up her mind about it, but I think after a little bit of time, she decided to go ahead and give the opinion that Sarah did suffer from battered spouse, and that corroborated what Dr. Harper had said, that she did suffer from battered spouse syndrome. So I guess that was a good of that.
Any thought in hindsight that maybe there was a motion to eliminate for you not to use the battered spouse syndrome defense, to not talk about self-defense? Obviously, you got to be able to do that. The state was very clear. She needs to say there's an overt act. She eventually did. She said his hand coming out of the suitcase was that overt act. In hindsight, could there have been another strategy that you could have taken that could have been more successful? Maybe not argue battered spouse syndrome?
No, I don't think so. I think, what she was saying in that 2-minute video to George while he was in the suitcase, I'm convinced was tied to the trauma that she had received from the abuse that she had suffered from George. And I just think Dr. Harper, you know, it's a complex syndrome. It really is. And it's difficult for lay people to understand. I've tried to talk to, you know, the psychologist, the psychiatrist about it to try to understand it. You know, why somebody wouldn't leave that situation. Why, you know, if they're getting beaten up, they're getting stabbed in the leg, why wouldn't you leave that situation? It's one of those things. It's a head scratcher for a lot of people. And so that's the reason you bring in expert testimony, is to try to explain that to a jury, what was going on. But it's difficult for people to really understand.
When Sarah Boone refused the plea offer, the judge made it very clear to her that the minimum he could sentence her to would be 22 years in prison. Is she prepared for the sentencing? It's going to be in December.
I don't think she's prepared. I don't believe that. You know, I think she was in hopes,
it's happening.
Excited about us, and she felt like she had a defense and that we were doing everything, and she had the experts lined up. So I don't think she was thinking about this at all. I think she was very optimistic. That's why she was optimistic during the trial. She was happy with us every day. She was happy with what we were doing. And of course, you know, she understood that it was a valid defense in Florida. Battered spouse using it to justify the force that you use. So, yeah, she's devastated, and she hadn't come to grips. Like I say, I'll talk to her tomorrow, but she was just stunned today.
Vinny also has a question. Vinny, what's the question?
Yeah, I had a couple questions for James. First, at the sentencing, will his judge have much discretion in what the sentence can be? And do you expect Sarah to express any sense of remorse at sentencing?
At the sentencing, will the judge, Vinny's asking, at the sentencing, will the judge have any discretion? This is her first felony. The judge made that very clear. So that's the first question. And then the second question is, will Sarah Boone say something? Will she express any sort of remorse for what took place? Will she make a statement in allocution at her sentencing? I know you have to take some preparation time.
Yeah, I think the prosecutor had said the low end of the guidelines was 22 years, and I think the judge told Sarah that. So I think that probably is the minimum, unless there's something I'm missing, maybe a downward departure. I don't know that she would qualify, but you know, the judge has a range, and the judge has the discretion, and the judge, you know, is going to hear from the victim's family, and then the judge is going to hear from Dr. Harper, and ultimately the judge is going to have to hear from Sarah Boone about this. I don't know what her position is going to be, but we'll see.
Mr. Owens, thank you so much.
Thank you.
I don't know what her position is going to be, but we will see. I think we know what her position is going to be, and it's what it's always been. She's not going to show remorse. She's not going to say she's sorry. She's not going to say she wished this never happened. I think this is a person who firmly believes that they did no wrong here. And the reason I say that is it's not like all of a sudden she's getting the hard reality check of being in custody. She's been in custody. All of this contentious, obstreperous attitude has been since she's been in custody. That's why, you know, it was amazing to me that she turned down the prison time, because she's already kind of got used to prison life for years now. And you would have thought, hey, they spelled it out for her, I'm sure. The actual time you're going to do, how much is that going to actually add up to, is not a whole bunch more than what you've already done. And she says no. That's a person convinced of their own position. That is a person convinced that they did nothing wrong. That is a person who feels validated in their own kind of self-righteous place of being correct. I mean, that's, I think, how she's lived her whole life. I think that's the person that was demonstrated on those videos that we saw in court. Person who feels that they've done no wrong. Problem is, when a person like that runs into the brick wall of justice, this is what happens. And I can almost guarantee you at sentencing, she's going to find that all to be a joke too. She'll probably say something along the lines of, woe is me, I'm suffering from this syndrome, I was abused, all of that. But as far as like, I wish I had done something different that night, I wish I could undo that night, she had that opportunity. She testified and she didn't take advantage of that opportunity to say any of that. I doubt she's going to say that to the judge. And I also really doubt that the judge is going to give her the low end of the sentencing. This is a person who allowed someone to suffer to death. This is not a quick death. This is something that is, you know, we're going to be talking about for years because of how traumatic that was to even watch, let alone for that man to actually suffer through those circumstances. She is a classic narcissist, Afton. I'm no psychologist, but you know, walks like a duck, talks like a duck. All right, let's get into, he did one more interview with Banfield, and I almost feel like he may have regretted doing this one, because she, I don't know. I'll let you guys decide for yourselves, but I feel like she really, really came at him during this. This one's much shorter, by the way.
Now by Sarah Boone's attorney, James Owens. Mr. Owens, it's great to have you back on the show. Thanks so much for being with me. What was your client's reaction to the verdict, guilty, read in court?
Yeah, it was this past Friday evening, and I would say shocked. We were not, and she nor I were anticipating guilty as charged. You know, we considered that the jury might convict her of a lesser charge, or of the first lesser was manslaughter and the second lesser was culpable negligence. So yeah, she was in shock that they found her guilty as charged, which was the second-degree murder.
I'm struggling to figure that one out because I had made a bet that the jury would come back under 2 hours, and they did. I found her wholly dislikable all through the entire process, from the moment she was arrested to the moment she was convicted. I can't imagine I'm alone. Everyone I've spoken to who's been following the case, albeit not in the courtroom, has said the same thing. They'll throw the book at her. Why did your client and why did you feel that wasn't going to happen?
Talk about a setup of a question. Am I right? You, sir, are the dirty attorney who represented a completely unlikable person, and she should have taken a deal, but she didn't, and everybody thought you did the wrong thing. Why did you do that dumb, stupid thing? I don't know. I like Ashley, and I just feel like she really let him have some gut punches during this interview.
Well, she actually did pretty good on the stand. Watch her testimony. As far as Sarah goes, she actually did pretty good, I felt like. But you know, ultimately, as you mentioned earlier, the decision as to whether or not to accept a plea offer or to take the case to trial is ultimately only the client's decision. You know, lawyer can tell her the pros and cons and the strengths and weaknesses of her position versus the state's position.
Sure. Did you recommend her to take the deal, and she went against your recommendation? Because knowing how she's been with the last, 8 trial attorneys who, she spent before you, I would imagine that would be a scenario, I believe.
Well, I'm talking. And, I try not to give my opinion initially. I want them to try to make the decision on their own, and then if they ask me for my opinion, then I give it to them based on
Did she?
Yes.
What'd you say?
Well, that was something that I suggested she strongly consider, was that plea. I think with 15 years, you do 80% of that sentence here in Florida, plus she'd done already 4.5 years. So she would have had, I think, about 8 years to do. So yeah, that
so
was.
She went against your advice. I sit here with a smile only because it's like I've heard this story so many times before, and I think you knew as well coming in as number 9
that she wouldn't take your advice. Have you had a chance to talk with her since the conviction, and is she rethinking her decision to ignore everybody who's smarter at this game than she is?
No, we haven't talked about that. You know, she's got a sentencing coming up December the 2nd, Monday, December the 2nd at 1:30. So we're going to deal with preparing her for that. She's going to speak at that. And then there's a pre-sentence investigation that the judge ordered. So we'll work on that. And the judge
What do you think she's going to get? What do you think the judge will sentence her to?
Well, you know, there's a range, and I think that the state attorney had said the low end was 22 years, and of course, life is the top of the range, and the judge is going to have to make a decision. You know, as you know, there was testimony that she suffered from the battered spouse syndrome by our expert, and also the state attorney's expert testified. Both of them agreed that she suffered. So there is some mitigating factors, although the jury did not find that she was justified in the use of force that she used as a result of the battered spouse syndrome. I think the judge can consider the fact that ultimately, you know, it was a dysfunctional, toxic relationship in which both of them probably abused each other.
Well, thanks for watching. All
right, they I don't know why, but we couldn't find a better clip of that. They for some reason cut off their own interview in the clip that they put on YouTube. But you know, I'm not saying I feel bad for the guy, but I guess I feel bad for the guy. He's got this hangdog look on his face. His hair is a mess. He's got his tie off. He's now wearing his glasses. He looks beat to hell and run over a couple of times. And this wasn't even the same day. It was a few days later. And Banfield's just not pulling punches, letting him have it. You know, how in the world did you guys think you had any chance of winning this thing? Why in the world didn't you take that plea deal? It's all quite in Banfield's defense. It's all the questions we want to know the answers to, but the poor dude's just on TV trying to do a little spin doctoring for his client, and she's just not having it. It was, I don't know, more than anything, it was probably more entertainment value to come out of that interview than anything that we could get some insights into this this case that we didn't already get from the first interview. But questions from you guys. Let's see. I want to make sure that we get to some of the questions that you guys had before we move on to some of the other things. How long do I think that she'll be sentenced to? This is difficult for me to say. And the reason for that is that this is taking place in Florida, and they've got different kind of sentencing guidelines and different ways that they handle these things. I will say in California, you know, it's a little more predetermined. There are certain things that the judge cannot have discretion on. Now, this is what's called an indeterminate sentence, meaning she isn't given a certain amount of years, and that's that. And then you can calculate when parole would kick in based upon credits. This is a sentence of such and such to life. And I am not an expert enough on the Florida rules. If there are people in the chat or you know someone, please let us know. But my understanding is that the judge can, within the discretion of 22 to life, give his sentence based upon things that came out in trial. In California, for instance, on a second-degree murder, it would simply be if there's no other allegations of different types of weapons or torture or whatever else being used, you start out at 15 to life. If there's, you know, a gun involved, that could add 10 years, that could add 25 years. So it could go way up from there. Phil Spector was sentenced on a second-degree murder, but with the gun allegations, I think it was in the neighborhood of 40 to life. So you can get X amount of years to life, meaning that you don't become eligible for parole until after that determinate part of the sentence is served. We're getting a little bit into the weeds here, and I don't know if it's more than you guys wanted to actually learn about all of this, but given the circumstances of this case, given her lack of remorse, quite frankly, given her history with this judge and the way that she's behaved, I don't see it being 22 years. I see it being more than that. I see him viewing this far more as a first-degree murder, and we could be getting into the 3 decades long type of sentence, in my view. But if you guys know better, please tell me. CJ says, were all the prosecution objections possibly appealable? There were almost 20 in the defense closing alone. They are appealable, but just because something's appealable doesn't mean it will be actually taken up by the court on appeal. You are correct, though, in identifying that in order for something to become an appealable issue, it has to be ruled upon by the trial judge, meaning you have to object to it, either defense or prosecution, and a judge make a ruling on that, because the appellate court can only really decide on rulings. Was that ruling an abuse of discretion or not? Was that ruling based on the law or not? So the objections, depending on how the judge ruled on them, can become appealable issues in the closing. But I think those were all well-founded objections, and I think they were all certainly well-founded rulings on those objections. And so, end of the day, I think this judge handled this case wonderfully. It was a mess of a case, but he handled it with incredible patience and with a view towards the long term, being how is this going to play out on appeal. B. Michigan says, after sentencing, is Mr. Owens done with Sarah Boone? She will have other attorneys for appeal. If I was him, I'd never want to see or hear from her again. Yeah, that's usually the way it works. Usually your retainer has an end date, meaning I represent you through trial period, nothing beyond that. And most trial attorneys are not going to represent their client on appeal anyways, because quite frankly, many of the times an appeal comes up, IAC, ineffective assistance of counsel, is an argument made on appeal. That may even come up here. They may even argue this man was not adequately prepared to do this trial with the amount of time that he had. And even though that's no fault of his, that is something that may become part of the appeal. So long story short, she will get a different lawyer and she will have far less interaction with that lawyer. We're not going to run through 8 appellate lawyers. She's going to have a lawyer. That person's going to get the case. It's far less about the client, far more about what took place during trial. They're going to get the transcripts and they're going to make their arguments. One more question from CJ says, does the judge have his decision about sentencing and hearing is pro forma, or does he take into consideration the victim's impact and lack of contrition? In a case like this where the judge has discretion, I do think he will take into consideration what is going to be said at the sentencing. And I do hope that he does that. That does not mean that he might not already have an idea in his head what is appropriate, and maybe he'll listen and see if anything changes his mind. So I would not be shocked if the judge, I would not be shocked either way. I would not be shocked if the judge heard everything and said, here's the sentence, or if the judge heard everything and said, I'm going to, put off sentencing for me to consider this. But most times that sentencing takes place that same day, even regardless of what people have to say, because judge can kind of gather what's going to be said by people. The victims' families are obviously going to advocate for one position, and the defendant and her supporters will advocate the other way. Pardon me, guys. I still got this tickle in my throat, so I apologize. Thank you for bearing with me. I hope I'm not blasting your ears out whenever I cough. All right. Let's move on to a little bit about Lori Vallow really quickly before I get you guys out of here so that we can go watch the Los Angeles Dodgers bring home the World Series trophy. Sorry to all my Yankees fans out there, but that is my sincere hope. But let's get to the rest of the new members that we had that I missed previously. That was Sam, Krista, Dare Stumble, Patricia, Molly Tahana, Paulette Kelly, Hope 8 Fear, Mom 23 Kitty, Sharon, Chloe T, Rihanna the Diva, and April Lindsay. You guys are all fabulous people. I will continue to list off our members for as long as I could possibly do it without making you all go nuts for the amount of names that I list out. But if we get into that realm, then those are good problems to have. And I am truly appreciative to all you people who continue to show up every single week and support us and continue to watch the video and content that we put out here. And yes, CJ, go Dodgers. And a quick shout out, I don't do this enough, to Tiffany and Kaylin, who are the absolute engine behind this whole thing. They're the moderators tonight, and they make this whole thing possible. Not to mention, Tiffany is my wife and mother of our 3 beautiful children, who Ryan just had her 4th birthday on this last weekend. And we celebrated that. It was really nice. All right, Lori Vallow. Let's do this really quick, and then I'll get you guys out of here. Lori Vallow has now said, let me pull this up, that she wants to represent herself at trial, which is absolutely mind-blowing to me. And I wish I had the actual motion, and the reason for that is I'm guessing it was handwritten, and I would have loved to have shown that to you guys, but I don't. What we do have is this, which is the minute entry saying that they received that motion, and I just wanted to talk about this really briefly. The motion, the court has received and reviewed a motion to withdraw dated October 21st. It is made by the Office of the Public Defender. So the public defender, first thing about this that we're seeing, is in on this. It is ordered withdrawing the attorneys of record in the Office of the Public Defender for further representation of the defendant, importing new attorneys for all further representation. The court also received a motion from the defendant requesting she waive her right to counsel and represent herself. The court will defer this request until conclusion of the pending Rule 11 process. That pending Rule 11 process, Pammy, thank you so much for that support and generous gift to the mods. That Rule 11 process is talking about her competency again. So here's all the things that are at play here. She has a right to represent herself. Actually, what she has a right is she has a right to counsel, and you can waive your right to counsel. She is saying, I am going to waive my constitutional right to have an attorney supplied to me. Everybody can represent themselves. You don't have to use your constitutional rights if you choose not to. Those are not thrust upon you. Your freedom and right of speech is not thrust upon you. Your right to practice religion is not thrust upon you. If you don't want to own a gun, you don't have to own a gun. Same goes with right to counsel. You don't want one, you don't have to have one. We're saying we can get you one if you need one, but you can also represent yourself. So that's at play. Then there's her competency at play. Competency for trial is a very low standard, by the way. It's, do you understand that you're on trial? Do you understand what you're being accused of? Do you understand who the judge is, who the jury is, who the prosecutor is, who your attorney is? Can you assist in your own defense? Meaning, can you answer your attorney's questions? Are you able to, we're talking about such a low threshold that it's basically those folks who almost are at the point where they cannot communicate and are at a complete loss as to what's happening. Those are the people who are incompetent. So very low standard. But Lori Vallow already fell out of competency in Idaho more than once. She had to be treated and receive medication to have her competency reestablished and allow her to be even placed on trial. So this is no small issue in this case, even though it's a very low threshold. Then at play here is the possibility of the death penalty in Arizona. I don't know where they stand on that or what decision has been made on that in this case, but you're still talking about a death penalty eligible case. And what is this going to do at appeal if he decides not to allow her to represent herself? The judge, I mean. So all of these things are in the judge's head in making this decision. In most cases, a client says, I want to represent myself. They're going to have a hearing. They're going to make sure they know what they're talking about. Competency is established. Are you sure? Let's have you waive all these things and acknowledge that this isn't a game and you can't just come back from this. And if we're in the middle of trial, you just can't throw up your hands. That's why they appoint standby counsel sometimes. But you can't just throw up your hands and say, I'm done with this little adventure, this little experiment. once all of that's kind of done, yeah, go ahead, have at it. I've handled those cases. I've handled cases as a prosecutor where they're representing themselves. It does happen. But in the case of this magnitude, with these kinds of consequences, with this much media attention, not to mention, is the judge going to think, what exactly is this woman's defense going to be if she's allowed to represent herself? This is a person who, by the way, we saw her in her, when she was allowed to give her own statement, believes she's done no wrong. She still is an adamant believer, as far as I know, in these kind of fringe cult religious beliefs that she has. Is he concerned that if he allows her to represent herself, that this whole trial will turn into her pulpit and that it's going to be just rife with all of this irrelevant nonsense that he has to continue to rein her back in? Now, you know, we saw this a little bit in the Waukesha Christmas Day Parade trial. You remember with, I think his name was Daryl Owens. If I've got that wrong, please correct me. But that trial was a bit of a mess because he decided to represent himself. But that's not just, I bring that up to say, just because it could be a disaster doesn't mean that they're not entitled to have their disaster. But a judge could say, I'm going to base this upon the Brooks, pardon me, thank you, everybody, Daryl Brooks. I'm going to base this upon the gravity of this situation, the importance of ensuring that this trial is not rife and riddled with appellate issues, that I'm not going to allow this person to represent themselves. That is not a small decision, but he might be thinking, of all the things I want to be trying to defend after this thing goes up on appeal, I'd rather defend that decision than all of the mess this could turn into if she actually is allowed to represent herself. I don't know. It's going to be very interesting. Tell you what, a trial that would have already been interesting had she not represented herself will turn into an absolute barn burner if she is allowed to represent herself. So, stay tuned for all of that. That was our next little bit of news. Caitlin, do we have any questions on that one? Pardon me. What happened if she's not competent to stand trial? Great question, Afton. She goes into treatment. She's declared incompetent. She goes into treatment and they try to restore her competency. She gets medication. She gets evaluated. That's why, if you remember, her case was on track to be trialed with her husband's case, Chad Daybell, but those trials got severed because they got on different tracks when she went out of competency, and the proceedings are halted. They're not released. It's not guilty by insanity. It's just everything's put on hold until we can figure out the competency of this person. And there are cases that remain there for years because that person just does not regain competency. But that does not mean that they haven't had their trial and that they've been acquitted or they've been convicted. They just simply are unable to be competent to stand for trial and are held in custody. All right. Jody says, there's no dumb questions, Jody. There's only me giving dumb answers. But if she already is in for life, why try and waste all time and money in Arizona? This is a good question. This happens a lot. The first thing that comes to mind right now is Harvey Weinstein. And Harvey Weinstein is actually an excellent example to answer your question as to why they do this. Harvey Weinstein was tried in New York for several counts. I think it was 2 counts of rape and other allegations of sexual assault. He was convicted in New York and he got sentenced to, I think it was 20-something years. Then LA put him on trial for almost the same thing, but things that took place in Los Angeles. And many people ask, why are we doing this? It's because, one, those victims are still entitled to justice. 2, that jurisdiction is still entitled to handle the crimes that were committed in their jurisdiction. And 3, there's a safety net. And you're seeing that now play out in Harvey Weinstein's case because that case got overturned on appeal. And now they're going to retry it in New York, but you can think about what a disaster it would be if that fell apart in New York and he wasn't convicted in Los Angeles. If that were all true, Harvey Weinstein might be walking the streets right now. So I think the bigger answer, and the answer you may get from most people, Jody, is that every victim is entitled to justice. We should not be concerned about resources, though it all is taxpayer funded. Every jurisdiction is entitled to get secure convictions out of their jurisdiction for the crimes committed. But end of the day, you can never know what's going to take place on appeal. Let's do one last question on this, and then I'm going to give you guys a special announcement and then go put on all my Dodger gear. It says, Brittany says, can they use her prior instances of not being competent against her for this? No. The way it will be handled is that she is going to be evaluated in Arizona by an independent mental health expert there about her competency. And if she needs to be treated, she'll be treated. And if she doesn't need to be treated and they say she's fine, competency is fine, and then this judge has to decide this very, very important issue. The reason why her competency issues in Arizona and Idaho play any role whatsoever is that it's not like this is a brand new issue. This woman has obviously been dealing with for some time with mental health issues. And I'm no expert, but just even seeing her demeanor and the way she responded and the way that she acts in court about the brutal murder of her own children, I can say she probably has some things going on in her head that need addressing. So her history will play a role in as far as the overall holistic evaluation of her mental health, but it's not like those are strikes against her in any kind of declaration of competency here. Competency will be determined by mental health experts and their presentation to the court. So all of you, excellent questions. Thank you, everybody, for being here. Will Freddie Freeman's show continue? I sure hope so. The guy is putting on a absolute show for the history books. It's incredible. I think the Dodgers need to win just for that alone. I mean, you can't have a walk-off grand slam and then not bring home a trophy. Okay, so, but more importantly, our announcement for next week. Our next guest is another person with a large following and a lot of fans and a very, very interesting backstory in the true crime community. And that is for our next episode in our Courtroom Confidential Conversations series is going to be Joel Waldman of Surviving the Survivor. He's a great friend of mine, a wonderful man, has a very interesting story with his mother. I know you guys are a lot of you are fans of him as well. So we're going to be doing an interview with him. A little bit of insider information here is that I have not yet done the interview. So if you guys have some questions you would like to know, please let me know and I'll make sure to ask him. But please stay tuned for Monday, 5 p.m. Pacific, 8 p.m. Eastern. We're doing our premiere, which is the next interview. It will be with Joel Waldman of Surviving the Survivor. I hope to see you all in the chat. We had such a wonderful live chat to the last interview and then incredible response afterwards. And I'm hoping to recreate a little bit of that magic again this time. Again, thank you to Gisela and the entire Grizzly Nation. Please tune in again Friday, you guys, as always, for our normal Courtroom Confidential weekly wrap up. Monday for the premiere on the new Courtroom Confidential interview series, our conversation series. And if all of that fails, I will see you guys again next Wednesday. Go enjoy the game. Have a great week, everyone, and go Dodgers. Take care, everybody.